All rise. High Court of Singapore is now in session. Judge Irfan in proceeding.
Good morning, ladies and gentlemen. Today, this honorable court will hear the case of Chaytor against Zalehah binti Abdul Rahman. Please be seated.
My lord, this case concerns the issue of divorce and maintenance. Chaytor and Zalehah, which were lawfully married at the Registry of Muslim Marriages, Singapore. They had a daughter named Diana, who was born on 5th December 1996. 4 years later, Chaytor pronounced a single talaq in the presence of 2 witnesses. On 24th May 2000, Chaytor filed Shariah Court summons, which dealt with the ancillary matters relating to the divorce, such as the amount of nafkah iddah, which is the maintenance during the 3-month period of iddah, and mut'ah, which is consolatory gift to be paid to Zalehah, custody of Diana, and division of the matrimonial assets. Prior to the pronouncement of the talaq, Chaytor had been paying Zalehah a monthly sum as maintenance for her and their daughter, Diana. This also stopped in May 2000, and on 16 June 2000, Zalehah filed maintenance summons in the family court for maintenance for herself and their daughter, Diana. The maintenance summons was heard on 24th August 2000. At the hearing, Chaytor objected to Zalehah's application for maintenance for herself on the ground that they were divorced as from the date of the pronouncement of the talaq, and that consequently, Zalehah was no longer eligible for maintenance under Section 69, subsection 1 of the Charter, since she was no longer a married woman as required by the section.
Thank you. Are all the parties present?
Yes, my lord, I am representative of appellant.
Yes, my lord, I am behalf of respondent.
Ms. Ashikin, please swear in the jury.
I, Nur Ashkim binti Aziz, having been appointed as a clerk, do solemnly swear or affirm that I will truly and faithfully enter and record all orders, decrees, judgment, and proceeding of such court. And I will also faithfully and impartially discharge all other duties of my office according to the best of my abilities and understanding.
Thank you. We shall begin the hearing. Counsel, you may proceed.
Thank you, my lord. Ladies and gentlemen, I will first present my case on behalf of the appellant. Before this, in district court, the appellant was the respondent of the case. He was brought to the court on the grounds of Zalehah filed maintenance summons in the family court. Mr. Chaytor disagreed with Zalehah's application for maintenance for herself because they were divorced as from the date of the pronouncement of the talaq, and that brings to Zalehah was no longer valid for the maintenance. The judge of the court below treated Zalehah as a married woman for the purpose of Section 69, subsection 1 of the Charter, and that caused Chaytor to pay for the maintenance towards Zalehah and Diana, the daughter, until the Shariah court held that the divorce was valid as of the date of the talaq. I would like to call upon the appellant to justify his claims.
Mr. Chaytor, please stand and raise your right hand. Do you promise that the testimony given in this case before this court shall be the truth?
Yes, I do.
Thank you, Mr. Chaytor. Please be seated.
I have questions for Mr. Chaytor. Can you please state your full name?
My name is Alan James Chaytor.
Mr. Chaytor, are you in any relationship right now?
No, I don't have any relationship at the moment.
Have you been in any relationship before?
Yes, I have had a relationship before, and I am the ex-husband of Zalehah binti Abdul Rahman.
Are the facts that I mentioned earlier correct?
Yes, all of the facts that you had mentioned before are correct.
May I know why do you need this order from the court?
I applied for an order from the court because I did not agree to continue to provide maintenance to Zalehah because we were already divorced and Zalehah are no longer had any rights over me as we are no longer husband and wife.
Thank you. I have no further questions for the appellant, my lord.
Counsel for respondent, do you have any question to the appellant?
Yes, my lord. May I know why do you refuse to pay some amount of money as a maintenance to your ex-wife?
She claimed that she was still my wife since the last date of the pronouncement of the talaq, and I was disagree with her claim based on Section 69, subsection 1 of Women Charter.
No further question, my lord. Thank you.
Counsel for respondent, you may proceed.
Thank you, my lord. The defendant is a wife of plaintiff named Zalehah. They were lawfully married on 10 December 1995 and have a daughter named Diane. Later, on 11 April 2000, the plaintiff pronounced a single talaq and files a Sharia court summons. After the pronouncement of talaq, the appellant had been paying his ex-wife a monthly sum as a maintenance for her and their daughter. However, this stopped in May 2000. I would like to call the respondent to clarify her actions.
Mrs. Zalehah, please stand and raise your right hand. Mrs. Zalehah, do you promise that the testimony... Mrs. Zalehah, do you promise that the testimony you shall give in this case before this court shall be the truth?
Yes, I do.
Mrs. Zalehah, please introduce yourself.
My name is Zalehah binti Abdul Rahman, Mr. Chaytor's ex-wife.
Please be seated, Mrs. Zalehah.
Mrs. Zalehah, what is your argument of provision that prompt you to take out of the maintenance summons?
Based on Section 69, subsection 1 of Women Charter, I asserted that my ex-husband had neglected and refused to maintain our 4-year-old daughter and me. Before February 2000, my ex-husband paid a monthly maintenance for of some $7,400. He also paid some household bills. For February, March, and April 2000, he paid only $2,500 each month. In May 2000, he stopped paying even that.
Mrs. Zalehah, are you sure that you are still a married wife after the pronouncement of divorce from Mr. Chaytor on 11 April 2000?
Yes, I am sure that I am still a married wife since my expiration of IDA would occur around 11 July 2000.
May I know why do you need this order from the court?
As my child is presently about 4 years old, on the basis that the child is entitled to maintenance till she is 21 years old, which is for the next 17 years. The amount in this dispute is $278,868. Thus, it far exceeds the threshold limit of $50,000 under Section 21, subsection 1, and no leave is required. In addition, he should pay for my maintenance for $1,500 per month until the conclusion of Sharia Court.
Thank you. I have no further question for the respondent, my lord.
Counsel for the appellant, do you have any question to the respondent?
Yes, my lord. Ms. Zalehah, may I know what do you do in life? Do you have a job?
Yes, I am a primary school clerk and I have been working for 7 years.
Ms. Zalehah, does your salary is not enough to support yourself?
Not enough. I need to pay the household bills and my daughter's attention as my salary only $2,000.
That's all from me. Thank you, my lord.
Does from the appellant side have anything to refute?
Yes, my lord, I have. For the purpose of Section 69, subsection 1 of the Charter, the civil court should treat a Muslim wife as divorced from the date of the pronouncement of the talaq. For that reason, when Zalehah filed the maintenance summons on 16 June 2000, she was no longer a married woman. According to Muslim law, a married woman is officially divorced as of the date the husband pronounces a talaq. More explanation can be found in AAA's thesis outlines of Muhammadan law. Moreover, the civil courts shall have equal or same jurisdiction with the Sharia court over matters of maintenance for any wife or child, as in Section 17, capital A, subsection 2 of Supreme Court of Judicature Act 1969 and Section 19, subsection 5 of the Supreme Court 1981. That's all from me, my lord. Thank you.
Thank you. Does from the respondent side have anything to refute?
Yes, my lord, I have some to refute here. The defendant is considered to be as a divorce from the date of pronouncement of the talaq. Therefore, she is not entitled for the purpose of Section 1969, subsection 1 of the Charter. That's all from me. Thank you, my lord.
Ladies and gentlemen of the jury, I am now going to read my judgment regarding this case. After examining the evidence from both parties, the court held that until the divorce was registered by the Sharia court and a divorce certificate issued, the civil courts would still view the parties as married. As of the date of the hearing in the district court, the Sharia court had yet to adjudicate on the validity of the talaq divorce. The respondent will be treated as a married woman for the purposes of Section 69, subsection 1 of the Women's Charter 1961. It stated that the court may, on the application of a wife and on due proof that her husband has neglected or refused to provide reasonable maintenance for her, order the husband to pay a monthly allowance or a lump sum for the maintenance of that wife. The appellant must pay to the respondent $1,500 per month as maintenance until the conclusion of the Sharia court summons and $1,000 per month as maintenance for her daughter. It was open to the appellant to apply to the family court for rescission of the maintenance order if the Sharia court held that the divorce was valid as of the date of the talaq. The court dismissed.